I am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today. We have a very special guest. We will be hearing from Laura Winston, and we're going to talk all things copyrights today. Not something that I feel like is readily talked about in the food and agriculture industry, but an important topic nonetheless. How are you doing today, Laura?
I'm great, thanks. How are you, Carrie?
Let's first set the foundation. I think there's a lot of confusion out there. I get a lot of questions on the differences between copyrights, trademarks, and patents. And I think that these three types of intellectual property are oftentimes confused.
Right. So a copyright is the exclusive legal right that an author or an owner has to print, publish, or perform either film or record literary, artistic, or musical material, and to give permission to others to do the same. A trademark is a symbol, word, or words that are established by use or can be registered to represent a company or a product, an identifier of the source of a product. And a patent is a government authority or license that gives a right to exclusively make an invention for a set period of time. It covers inventions, trademarks covers brands, and copyright covers creative works. There can be overlap among the three, but that's the basic way to sum it up.
So in the agriculture context, I'd like to just use a farm for an example. So like the farm brand name, like my parents' farm is Rinker Simmentals. That would be a trademark. Is that correct?
Mm-hmm.
Yes. And then, any logo, my dad came up with a fancy Rinker Simmentals logo with some genetic symbols. That is also a trademark. Is that right?
Oh, but it can also be copyright protected as a design, as a work of art. So there the two can overlap.
Okay, interesting. And then as far as, photographs and artwork, that would be a copyright, but not a trademark.
Yes, correct.
And then the patent would be things like, how like specific kinds of machinery or farm equipment and things like that.
Yes, exactly. So if they're new and novel, they can be patented, and the inventor can have the exclusive right to manufacture or license the right to other people.
So copyrights, trademarks, patents are the most prevalent forms of intellectual property. And I was just curious, are there other forms of intellectual property that are out there that are sort of covered in the IP umbrella?
Trade secrets falls in that category. Basically, the secret formula for doing something that may not be subject to any of these other protections, but still the owner can claim proprietary rights. Right of publicity, which celebrities rely on, is also sometimes lumped into the intellectual property category.
So I'm always a little confused sometimes on like what falls into a trade secret and what does not. What's sort of your general rule on that?
It's really going to depend on the circumstance, and it's often driven by agreement. So if an employer and employee have a non-disclosure agreement, then the employee is bound to protect any trade secrets.
All right, interesting. So what exactly can be copyrighted? I know that you gave a few examples previously with literary and artwork, but can you kind of go in a little bit of the laundry list on exactly what can and what cannot be copyrighted?
Sure. So it's anything that's original, creative, and fixed in a tangible medium. And by that, I mean that if you have an idea, you can't copyright that idea. But if you have an idea for a story and you sit down and you write that story, or even an outline of the story, then the fixed work that you've created is subject to copyright protection. So it's works of the visual arts, it's musical works, dramatic works, software code can be protected by copyright. It's anything that's original and creative and fixed in some form or other.
So we have some food entrepreneurs listening, or, those that just like to cook. And so those special recipes that people want to protect, that type of intellectual property, can that be protected with the copyright?
So generally speaking, like a list of ingredients can't be protected. So the ingredients that you use, the list of the ingredients, and even the steps that you would follow to create the recipe are generally not subject to protection by copyright. But the way you might create a cookbook with, elaborate layouts and stories, like that could be protected by copyright. So the recipe itself, no, but certain ways of displaying the matter, the answer would be yes.
So something that I advise my food entrepreneurs who are wanting to keep their recipes private is I encourage them to have their employees and independent contractors sign a non-disclosure agreement. Am I missing anything with that, Laura?
No, that would be the best way to do it. Again, we get back into the trade secret, the secret formula X realm with that, and that is the best way to try to keep those recipes from getting out into the public.
So as you know, I like to write articles and I have blogs and different things on the web. And at the bottom of the page, I put that little C, the circle C, the copyright symbol. Then I put the year, it's 2018, Rinker Law P LLC, all rights reserved. I recently did that. I have a JD Super page, and I recently put up a chart of that my law clerk created, cross comparing different co-parent applications. And I'm just curious, what value do you think that really brings to the table, that copyright at the bottom?
So having that material is a good idea. Putting the C in the circle, your name, and the year are advisable. And that way, if somebody copies it, infringes it, they can't claim that they did so innocently, not knowing that it was protected by copyright. That can affect the damages award that the copyright owner might get. All rights reserved is somewhat optional. You don't really need to have that in there. Nobody can copy or copyright your material without your permission anyway. But the symbol or the word copyright, and by symbol I mean that C in the circle symbol, the name of the author and the year of the work are all recommended.
All right, interesting. Now, with the year of the work, does it mean that it's only good, the copyright is only good for that 1 year?
No, it just means that was the year that it was published or created and the content was made available, or really it's the year that it was created. Copyright protection is quite long, thanks to the Sonny Bono Copyright Term Extension Act of 1998. You can have an individual has a copyright that lasts through the individual's life plus 70 years.
Oh, wow. Okay.
If a company or another entity that's not a person owns the copyright, it's good for 95 years. And that law I mentioned is sometimes called the Mickey Mouse Protection Act, because it was actually Disney and other of the older entertainment companies that lobbied to have that long a term, because Mickey Mouse cartoons were about to fall into the public domain.
So I hope I'm not alone in this, but I have stolen a few pictures off the internet before, Laura. Yeah, you have heard me admit it before. So I actually one time got a cease and desist letter for some picture that I grabbed on the internet, and I immediately took it down. And since then, I'm so freaked out that I'm going to steal somebody's copyrighted work accidentally, that I now buy all of my pictures I use on my blogs from Fotolia and iStock Photo. So I'm just curious, Laura, how does a person know when they go on the internet that certain photographs and images might be copyrighted?
So you're not alone. People do assume that things that are prevalent on the internet are just available for anyone to use, but unfortunately that is not the case. And really you just need to assume that everything is copyrighted. As I mentioned, you have a copyright from the moment something is fixed in a tangible form. And even every photo that you might have on your iPhone is protected by copyright. So unless you know that a particular photograph is more than 95 years old and it was owned by a company, you have to assume that it's protected by copyright. And that's why you're doing the right thing now by going to licensing sources like iStock Photo before just taking something and putting it up online.
You know, and honestly, it actually makes me feel a little bit better because
the business model on going after these internet uses. So it really is the safest thing to do, and often not very expensive.
So it actually makes you feel better, I think, as a business owner, because at least the photographers or the graphics designers are getting some of that money. And, you know, as an attorney, like, I want to be paid for my services. And so, you know, I think that it's the proper thing to do is to go out there and pay for those graphics and those photographs that you want to use in your advertising materials.
Yeah, and that is the rationale behind copyright law. And it actually goes back to the original U.S. Constitution.
All right, so we have some listeners who are livestock and agriculture photographers. Laura, I don't know if you know this about me, but I used to be a professional cattle photographer.
Wow.
So, yes, it's all about, you got to get the ears, you know, moving forward on the cow. So there's a whole technique to it. But at any rate, should these photographers be filing copyrights with the U.S. Copyright Office?
Yes, that is recommended. So as I said, you own a copyright from the moment that you create the work. So as soon as they've taken their photos, they have a copyright in those photos. But you can't pursue anyone who copies your photo, who infringes that copyright without having a registration of the copyright. So it is recommended to file with the U.S. Copyright Office.
So Laura, I know that you also do, obviously you do trademarks. We've worked together on these things, and conceptually, farmers and food entrepreneurs can have what's called a common law trademark. You're familiar with that term, you know, first in time, first in right. And you're perhaps incorrectly, but I tell my clients that they right now already have trademark rights if somebody else is infringing upon their mark. Am I incorrect on that you can't really pursue somebody who's infringing upon your trademark the same way that you can't infringe or can't sue somebody who's infringing upon your copyright unless you file?
That is not the case with trademarks, so the advice you've been giving is not incorrect. You have just as you have copyright protection from the moment you create the work, you have trademark rights from the moment you start using that trademark when you're selling your goods or rendering your services. The difference between copyright and trademark is you can still go after a trademark infringer without a registration, whereas you cannot go after a copyright infringer without a copyright registration. There are a lot of benefits to trademark registration, don't get me wrong about that. So it's often recommended for anybody who's doing business in more than one state. But it's easier to prove that you own a valid trademark, for example, if you've got that registration. But you don't need to have a registration to enforce your trademark rights and even take somebody to court.
So since it's a prerequisite to copyright enforcement to have a copyright that's been filed and registered, does it matter what happens first? So what if somebody infringed on the copyright and then you later went to the U.S. Copyright Office to file and register that mark? Is that going to make a difference in terms of enforceability?
It doesn't make it. It still allows you to enforce it if you get the registration after the infringement occurs. However, it does affect the amount of damages you would be able to correct. So in most cases, it's better to do the registration as soon as you can rather than wait until you have to. In addition, the filing fee for copyright is really not very expensive at all. It's $55. But if you want to get that registration certificate in a hurry because you want to sue somebody, then you can request an expedited registration, but it costs about $750. So that's a great 55 versus 750. So that's another incentive to do it earlier rather than later.
So I have copyrighted both my books, as you know. So I sort of went through that process, and I'm trying to think what the timeline was on that, going the regular way. I want to say it was a few weeks, or maybe I'm wrong about that. Do you know what the estimated timeline is to get a copyright?
So from the time you file it, if you're not doing that expedited procedure, it can take several months to over a year. It's a very backlogged, busy government office. We'll go back to the date that you filed the application. What is not clear, and this is actually a case that's going to be with the Supreme Court next term, is whether you need to have the registration in hand to sue somebody in court, or whether it's enough that you filed your application in order to go into court. That's a case to watch.
All right, very interesting. So you mentioned a little bit about the filing fees, Laura, and I'm wondering if you can talk a little bit about the statutory damages if you are found infringing on somebody else's mark, or if somebody infringes on your mark.
So, well, we're talking about copyright, though, right? Not
copyrights, yes, not trademarks. I apologize.
And this is something that's commonly done when you get these cease and desist letters from the photograph rights holders. Copyright damages can escalate quite a bit, and there's ranges that are governed by statute that will depend on how innocent or guilty the infringer is, and the number of occurrences of infringement that the infringer committed. So it depends on the specific situation, but they can escalate quickly.
So what should somebody do if they see somebody else using their copyrighted material without their permission?
So in that case, step one would be to make a record of the infringing content. So if you see it on a website, make screenshots of the website. Or if you see it in some other form, take photographs of it. The reason for that is that, content can change. Somebody can take it down before you've had a chance to reach out to them about it. And you still would be entitled to pursue them for infringement, even if the content is only up there for a short amount of time. That would be step one. Step two would be to contact an attorney to get advice on the best way to handle it. Generally speaking, you wouldn't want to contact the infringer directly without first being in touch with an attorney, because it could affect, you could inadvertently say something that could affect your rights. An attorney would be in a better position to advise how to go forward.
Yeah, that's good advice. And similar, how should somebody react if they get one of those cease and desist letters? For example, one time I was volunteering with a livestock organization, and they inadvertently, published a poem without getting the permission from the author, and there was a cease and desist letter. How do you advise livestock organizations or private businesses that are listening here today if they get one of those cease and desist letters?
So the first thing to do is not panic. These things can often be resolved. The best course is not to do it in the first place, but if you have and you get a letter like that, these things can often be resolved with minimal pain. And then I would recommend contacting an attorney to get advice on the best way to respond. It may be, admission, yes, I did this, I'm not going to do it again, and then working out some kind of settlement, if any, or it could be a defense of the infringement. And again, I would recommend against contacting the letter writer directly, because whatever you say will be recorded and potentially used to try to inflict more pain than if you're working with an attorney whose goal it is to try to resolve the matter in your favor as best as possible.
So a lot of our listeners have websites, and if you are listening and you do not have a farm website, then you should get one. And I think sometimes there's a little confusion on who owns the copyright. Is it the graphics designer, the website company, or is it the farmer or the food entrepreneur? So any thoughts on that, Laura?
Yeah, in that case, you'll want to have agreements in place that designate who owns the content, and they're often referred to as work made for hire agreements. If you hire a graphic designer to design the website, you should have an agreement that says they're doing it as a work made for hire, and that you own the copyright in any content and designs that they come up with. Otherwise, it could be subject to a dispute down the road over who owns what, and they could try to take the same content and use it on another person's website.
So I know trademark law is federal law. Copyright, do you also consider that federal law, or is it both state and federal law?
Copyright is also federal law. So that means
you can work with clients, all over the country, not necessarily in New York. Is that right?
That is correct. The only exception is if there's litigation in a court outside of New York. I can't work with that client by going into that court. But even in that case, we could retain local counsel, and a person can be admitted just for a particular case into a court in another jurisdiction. So yes, that is correct. Thank you.
So since we have listeners from all over the country, where can people find an intellectual property, or more specifically a copyright lawyer, if they prefer to have somebody closer to them? What would be some recommendations there?
Oh, a good thing to do would be to reach out to your general business attorney or your personal attorney for a referral. Or if you have difficulty finding somebody that way, you'd be welcome to contact me, and I could hook you up with somebody in my network.
All right, fantastic. Well, Laura, thank you so much for your time and your expertise, and appreciate having you.
Thank you so much for having me on, Carrie.
All right, our next question for Ask Carrie comes from a farmer in Iowa. He writes, what are some considerations for farm machinery purchase contracts? So buying farm machinery is a long-term purchase, and there's multiple ways to go about obtaining this equipment. One way that I've seen is just the outright sale. So an outright sale occurs when the ownership is transferred to the buyer and the seller is paid in full at one time. The second type of farm machinery purchase contract that I've seen is an installment sale. So the buyer obtains immediate possession and the use of the machinery, but the seller obtains payment on a set schedule, which can be over a short term or it could also be over a long term. And then the third major type of farm machinery purchase contract is the gradual sale. So this type of a sale is when a line of machinery is being sold one or two items at a time. So don't get that confused with a long-term installment sale. So a gradual sale is really whenever several pieces of equipment are being sold, but just one at a time. So here are a few other types of farm machinery purchase contracts. One is with a lease with an option to buy. I've seen this a time or two. And this option allows a party to lease the equipment for a set term and then purchase the equipment upon the completion of the lease. A second type of lease that I've also seen is a lease with a gradual sale. And remember to go back here with this gradual sale that we just mentioned, is that whenever you are buying a series of farm equipment, but one at a time. So along those same lines is that the lease with a gradual sale is that you are leasing multiple pieces of farm equipment and wish to purchase them during the terms of the lease. And then the final type of farm machinery purchase contract that I have seen is a rollover purchase. And this type of agreement allows a purchaser to acquire new or nearly new equipment each year. The purchaser pays the difference between the price of the new model and the trade-in allowance for the old one. This allows a purchaser to have new machine that is generally still under warranty, and thus eliminating the cost of repairs. This type of purchase can also be used to purchase equipment that is 1 or 2 years older rather than brand new to save on costs. So in terms of the considerations for farm machinery purchase contracts, I think the first question is, what type of agreement are we looking at right here? And if you have any specific questions, make sure to talk to an attorney licensed in your jurisdiction. If you have a question that you would like for me to address on this podcast, please be sure to email me at Carrie@rinkerlaw.com. Put Ask Carrie in the subject line so I know that you are referencing this podcast, and I will hopefully be able to answer that in an upcoming episode shortly. So again, that email is Carrie, Cari, at rinkerlaw.com, spelled RINCKERLAW.com. You can also find me online on a whole slew of social media platforms. I'm trying to be cool with the kids with the Snapchat now, and Twitter, Facebook, LinkedIn, Instagram, and YouTube. While you're there, please be sure to subscribe also to the AgLawToday's YouTube channel as well. See you there.